Welcome. I am John Miller, the founding attorney and senior attorney at Rock Solid Law and Title. We founded our firm here in Ponte, Vedra in 1991. We continue to provide estate planning, real estate, and business services, all transactional, no litigation other than helping a family through probate when absolutely necessary. We're going to be talking about probate a little bit in the next few minutes. And so I would like to mention the two areas that we're not really talking about a lot today in which we practice. The first is real estate. And what that means is we help people transfer the sale of their homes, including acting as escrow agent, closing agent, and as title agent, providing and proving that there's good and clear title in the transfer. So in Northeast Florida, the seller has the option to choose who closes. And we would like to suggest to all of you that you tell your friends to let Rock Solid Law and Title take care of them. We assure you that they will get professional services and we will close professionally and on time, taking the stress out of the closing process. The other area that I practice in is a business law. I am a transactional lawyer. That means I write, review, and negotiate a lot of contracts. Basically, I take care of entrepreneurial small business owners and make sure that they enter into good deals and that they make good money, because I believe that small business is the heartbeat of the American economy. And we want to make sure that our clients are well taken care of and that their legal backside is protected. Today's webinar is with respect to trusts. You know, trust is a term that includes a whole lot of different opportunities for planning for the future of those you love, planning for legal reduction of taxes, of not paying taxes necessary, planning for asset protection. So what a trust is essentially is a problem solver. And let me tell you three of the problems that the most basic trust will solve. Today, we're going to focus mostly on a living trust, often called a family trust. The fancy name is inter vivos revocable trust. Inter vivos, created during life, is all that Latin means. Revocable, you can change it by written revision anytime you want to, as long as you have allowed yourself the ability to do so. So first and foremost, we're going to talk about trusts that are created during life. There are trusts that are created by, for instance, a will or other intestate document that don't come into being until after the person who wants to create the trust dies. These trusts are all during lifetime. And so they're going to be taking care of the grantor, you, if you're the one who establishes it, during your life. And they're also going to plan for the future. So I said a minute ago, trusts solve problems. Often they're problems people don't even know they have. So let's talk about what problems a living trust would solve. First and foremost, a living trust keeps your estate from going through probate. Why do you care about that? Because probate means a lawsuit's filed. When a lawsuit is filed, that means that you subject everything you accumulated during your lifetime and wish to leave to someone or something you love to the courthouse. That means that all of your earthly goods will be subject to a judge. In most cases, judges are appointed by politicians. So you have essentially said that you would like the decision for how your stuff is handled to be managed by a political appointee. I find a few things to be true in the 38 years that I've practiced law. Most people want to minimize the amount of taxes they pay to the government, however they can do so legally. And most people agree that about the worst person to make decisions on your life or for your loved ones is a politician. No offense to all the good, hardworking civil servants out there, many of whom are my friends. But if you just want a random politician in charge of your stuff, leave a probate mess for your family. The second problem it solves, probate is messy. Probate is where people come to fight. It's where your children or other people you love will make a cash grab for whatever they can get out of what you've left behind. It is where family relationships break down. It is where siblings go to never speak to each other again in their lives. And I am one of the most optimistic people you'll ever meet, but I've lived through this scenario time and time again. I've got the war stories to prove it. And it is awful, 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 awful. And so what does that do? First and foremost, leaving a probate means that your assets are not going to get to the people you want them to get to in a timely manner. They're going to have to wait until a judge says it's okay. And today is not the day that I'm going to teach probate, but if you really want to know all about probate, go to Rock Solid Law /webinars or /webinars. I always say the slash wrong. /webinars. Scroll down until you find one about probate. If you want to know about the probate process, there are a few fortunate probates that whiz through without any delay, without any problems. But I'm telling you, those are the rare cases. You just never know what's going to happen. By filing a probate, you subject your estate to creditors, right? Sometimes fake and fraudulent and scamming creditors come out of the woodwork and file a claim. Your heirs don't know if you really had that debt or not, and it might get paid out of the money you meant to leave behind. So we've got a mess in probate where families go to fight. There's a delay in the transition, and you might subject yourself to fraudulent creditors. The statistics show that an estate that goes through probate will lose a minimum of 10 and more likely 30 to 60% just by going through that process. That's gross. Who gets that money? Some lawyer you don't know, probably your heirs, your kids, pick some lawyer that you didn't even know, and they're going to charge a pretty penny to take your will through estate. It's also going to be creditors. There's potential for taxes. There's of course court fees. So you're paying for all sorts of things to buy, delay, fighting, and ultimately, and here's my biggest piece for my clients, ultimately it affects your legacy. What does that mean? Oh my gosh, I can't even tell you how many times after a live seminar, somebody comes up to tell me a story about what Uncle Frank, and I'm making Frank up, Uncle Frank did at the funeral because he wanted his brother's fill in the blank. Maserati, gun collection, savings account. Your dad promised me the house. How about this one? To the widow, how soon are you moving out of our dad's house? That was after a 30 or 40-year marriage for the kids from the first marriage to say that at the funeral, man. You need to plan so these things don't happen, because you know what? The rest of their lives and the stories they tell their children, your grandchildren or great-grandchildren, are going to be about the mess that was left behind. And a lot of good works in life get swallowed up by leaving that mess. All right? There's great reasons to avoid probate. And how do you do that? A live-in trust. A live-in trust, and you just take that living hell away from your heirs, okay? Now, people go, when should I consider a trust? I start thinking through a trust with a family that has at least $300,000 in total assets. Total assets. At 500, at $500,000, I think it's almost a no-brainer. When you get up above $500,000, and most people that own a house in Florida and have a little bit of something else are in that category, you really need to consider about having a trust package as your estate planning. Now, listen, there are all sorts of other reasons, to do your planning package to take care of yourself during your lifetime, to not have to go through a guardianship while you're still alive, to have somebody there to take care of you when you're hospitalized and can't deal with it, to tell how you want to be treated during your last illness, and to have somebody take care of your bank account, paying your bills when you can't do so. Okay. All of those things are accomplished in the overall package of planning. But now back specifically to that revocable living trust, or we're just going to call it a living trust this morning. That trust, merely by entering into that agreement, is going to allow you to completely pass by probate and will allow your successor trustee to immediately take control of all of your assets at the moment you're unable to control them or you pass away. Immediately. Cost. People always want to know cost. I'll tell you something. From a 38-year lawyer, any lawyer that is quoting costs and fees without knowing what problem they're going to solve for you isn't worth their salt or the ink they put that quote on, or the breath they use to say it over the telephone. They can't know how much it's going to cost to do for you what you need. I get people asking all the time, well, how much is that? I'm like, how much is what? I don't, and we don't know what until we talk. Okay. So until you consult with an attorney who knows what they're doing, and I underline knows what they're doing, because there are a lot of lawyers who do other things that think they can do a will or a simple trust, and they make a mess. I'm fixing one right now, today, yesterday, started on last night, stayed late last night, and they don't know what they're doing. Woo! See, there's the universe emphasizing what I said. Find somebody that knows what they're doing, right? When you get somebody to invest your money, you want somebody that knows what they're doing. When you get somebody to write you a life insurance policy, you want somebody that knows what they're doing. Heck, you even want a car salesman to know something about the car they're selling. When you get a lawyer, make sure they know what they're doing. And your divorce lawyer probably doesn't, right? And the criminal defense lawyer that got your kids off a DUI, they don't know what they're doing with the will or trust either. Okay, that was aside. So people want to know what they cost. I'd rather focus on what they'll save. If you've got $1 million estate, they're going to save you $100,000 to $300,000 to your heirs, and that's just a basic level trust. All right. The truth is, you can pay for a trust package now, or your family or your heirs can pay for a probate later. And the probate later is going to cost more than it would cost to do adequate planning now. Say that again. It's going to cost your family, the people you love the most, more after you're gone. And how happy is that going to make them? Than it would cost you to get the job done right now. All right. So there's some of the problems that what we're talking about will solve. So what is a trust? A trust is an agreement between a grantor or settler and beneficiaries. Guess what? That grantor or settler can be the same person as the beneficiaries during their lifetime on a revocable trust. And it typically is. It is you putting all of your assets into this thing called a trust, and that trust existing to take care of you during your lifetime. And then you get to say, and after I don't need this stuff anymore, after I don't need what I have worked for my lifetime or what I inherited from my family anymore, here's how I want you to dole it out. Here's who I want you to give it to, and here's when I want you to give it to them. So guess what? With a probate or a will, your heirs inherit right now. Here's another problem a trust solves, right? I'm 62 years old. I made better decisions yesterday than I made when I was 40. And I made better decisions when I was 40 than I sure did when I was 29 or 30. And even at 30, I made better decisions than I did at 18, right? Guess what? 18 is the age of majority. If you don't have a trust, your kids, your heirs are going to get everything at 18. And I'm telling you, history shows, statistics shows, however you want to talk about it, that it's gone before it does them any good in their lifetime. They'll have a good time, they'll blow it. So in a trust, you're able to withhold that until a time when they're more mature. You're also to withhold their inheriting it until perhaps they get through those early adult years of their life, when statistics show there's a really good chance that they may fall for someone, marry them, and divorce them. And guess what? If they've inherited everything, half of that goes to your future ex-son or daughter-in-law. Half of it in the divorce. Get it? Now, if they don't inherit it until later years, it's not taken into consideration in the divorce. So a grantor or settler puts the money in the trust for the benefit of somebody, usually yourselves during your lifetime. Let's take a married couple, for the two of them during their lifetime, and for the survivor of them after the first one goes. And then they've made a plan together on what's going to happen after they're gone. Is it going to go to charity? Is it going to go to their children? Is some going straight to their grandchildren, right? Well, what about generation skipping? What about spousal interest? What can we do down line to save on taxes at this very basic level as well? So as I mentioned, there's so many different kinds of trusts, and they each have a different purpose. So the living trust avoids probate and is one of the only mechanisms that can be used for controlling your assets from beyond the grave. Okay, so you will have set out a plan inside the trust for what is to happen to those assets and how your successor trustee is to pay for those items after, and sometimes well after, you are gone. So I like to think of a trust as a basket. All right. It's a basket that you hold on to during your life. It could be a backpack that you carry during your life, whatever receptacle you like to make it. We take everything you own and we either put it in the trust or we make it the death beneficiary after your life for something like retirement qualified funds. So everything goes into this basket, right? Now, at the bottom of the basket, I want you to imagine a funnel. And eventually, or starting right now, the trust money will come out that funnel. And you get to make the rules. You get to make the rules on how, when, and to whom that money comes out. Typically during your lifetime is to you. Typically, for our married couple, it's to the spouse who survives during her lifetime. And then typically, it's going to be for the children, if they had any, or other people that they love, and maybe to some charity. So if you want to not have everything you've worked for lost by an immature adult, a trust solves that problem. I guess another way of saying that, we also insert a spendthrift clause. It's a way of protecting those people you love from themselves. So now you got a grantor or settler, and you've got beneficiaries. And you got beneficiaries during the lifetime of the grantor and beneficiaries after the lifetime of the grantor. And we can write the rules on how and when that is doled out any way that you want that is not illegal, right? We don't participate in illegal. But for instance, I have had families who wanted their child to be entrepreneurial. So there's a committee that particular trust formed to determine when that child can receive funds for entrepreneurial ventures. And there's a very low bar for receipt for the first try. And then if he fails, there would be a higher bar the next time. I think the third bar, he's got to go get an MBA. If he crashes 2 businesses to get any more, he's got to work real hard. There are people who particularly are concerned about drug or substance or alcohol abuse, and therefore insert that before someone can inherit, they have to submit to drug testing and be clean. Others care about not ruining their children with money and making sure that they still have a work ethic. I have written a trust where to inherit, the child must have The adult child must have had a job for 10 of the preceding 12 months. We didn't say the full 12 months because what if something bad happened? We wanted the trustee to have some discretion there. So if they've lost a job during the year before they were supposed to inherit, they'd have the 2 months within which to get a job back. So whatever your priorities are, you can put that in there for their inheritance. You also can provide for college education, even beyond college education, if that is your choice. Of course, you provide for healthcare money, health, education, welfare. Some people provide for travel because it's important for them, for their heirs to get a good worldview. Often a complete distribution doesn't come until a certain age. And the point is that you and only you decide when that is. I tell people all the time, I remain agnostic with respect to when people distribute funds. They always ask me, what does everybody else do? I always say, well, it doesn't really matter, but a lot of people give an entrepreneurial or a first home down payment tranche in the 20s and then step out into the 30s and even into the 40s, other distributions. Sometimes it's by thirds, sometimes it's by fifths. I regularly have people go out to at least 45 years of age. Yes, the children don't like getting everything, but ultimately they tend to mature, and to receive something even in their mid 40s they're grateful. It's like, wow, mom and dad really thought about me. My parents really loved me and they wanted to make sure I was okay, even to this late age and stage. And of course, we write in there, if there's an emergency, an urgency, a medical need before those ages, of course, the trustee could have, if you wish, the ability to disperse at that time. Now, I've talked a lot about a trustee. Most people serve as their own trustee during their lifetime, or at least during their competence. And then many people pick a trusted family member, typically somebody that has some compassion, but also has some financial ability, because they're going to be responsible for managing money. People also ask if they are paid a reasonable fee. And yes, we typically provide for a reasonable fee for the trustee. If there's not someone in whom you have confidence to fill that role, or if you just choose to do so, if there are professional fiduciaries who will serve as a trustee, and they're bonded, and while of course there is a fee attached to their services, as there well should be, they are by law fiduciaries and will carry out your wishes and are a good solution for many families. I do want to point out that the revocable or living trust does not offer asset protection. There are many trusts that offer a significant degree of asset protection, but this level of planning does not offer asset protection. So if asset protection is your goal, we need to consider some other alternatives. So this part confuses a lot of people. Remember my basket? Well, for things to be in the basket, they have to be titled into the trustee representing the trust. So all of the things that you own, your bank accounts, your market accounts, your real property, or the LLCs you own, it depends on what a person owns. They're all going to get retitled into the name of your trust, or they're going to be the death beneficiary of certain accounts, including qualified retirement funds, which cannot be titled in the name of the trust. People worry, oh my goodness, does this mean I'm losing control of my assets during my lifetime? Absolutely not. You maintain complete control under this trust. I often say it's as if you removed a dollar bill from your left front pocket and put it in your right front pocket. It is still yours to spend. It is there for you. It is there to take care of you during your lifetime. I realize I've run just a titch long today. I've got a few more minutes. I hope you can hang with me. With a will-based plan, there is not necessarily a trust, or there will not be probably a trust if you're using a will and want to send your estate through probate. With a trust-based plan, there is a will. A lot of people are surprised to learn this. The purpose of that will is to allow for a very simple probate process to transfer title to your assets after you're gone, if you failed to do so during your lifetime. So first and foremost, we want to transfer everything during your lifetime. If not, we provide a pour over will, which pours everything into that basket that you forgot to do so. I often have people who will create a bank account after we've met and forget to put it in the trust. Sort of tends to be people's mad money or vacation or whatever hobby account. But if we can, we like to remind people to get that moved so we don't have to do that probate. You might be picking up that I'm not pro probate. There are other law firms around here that are, and they and I have a difference in philosophy, I'll say, a disagreement on putting our clients through probate. Why? Why do they want to do it? It's very profitable. It's very profitable. So if you want to help the profit margin of those law firms, I'm sarcastically saying, please do. That will be your decision rather than to take care of the people you truly love. So the pour over will could transfer everything after death. We try to make it completely obsolete, but it is a necessary part or a safety net as part of your package. Let's see. I touched on grantor, settlor, beneficiary. Those are the people who are going to be taken care of by the trust. There can be a co-trustee. That means that is man and wife who choose to be trustees together are co-trustees. And then another term I've used today is a successor trustee. That's the person who you've appointed to take over after you're done. And remember that we said that you can change anything as long as you have legal competence. Well, that goes also to trustees. You can change out who the trustee is anytime. You can also change your mind on who you want to receive. I've had people that come back to me every few years to take beneficiaries in and out of their will. And so it can always be changed. Yes, there is a cost associated with that, but it can be done. So you're not locking yourself into a permanent decision by any means. So I am wrapping up only a few minutes over the usual time. And I would like to thank all of you for attending. If anyone does have a quick question, I would be glad to touch on it, even though I'm a minute over. And for being here this morning, to thank you. We would be really happy to offer you a $500 discount from any trust-based plan. That's approximately a 10% discount for you. Could be more, could be less, depending on what you need. But we will give the flat 500 to any of you who wish to call by the end of the day tomorrow, this week, schedule an appointment. And if it turns out that you choose for us to represent you, we will give you that discount. So I know this is a lot of material, folks. And I know, I had a law school classmate that said lawyers sprinkle Latin like so much salt on a meal. Lawyers like to make it seem like this is all so mysterious. It's not. It's just that I've done it over and over and over for many years, and so have any number of other estate planning attorneys. We know what we're talking about. You need a lawyer who knows what they're talking about and can lead you easily through this process. What's the difference between Rock Solid Law and other firms? We like to call ourselves beach professional. We try to keep everything light and happy while providing completely professional services. So this is not a dour experience. We are writing the ultimate chapters of your life through this trust and taking care of those you love most. By the way, there are studies that say that stress reduces lifespan. Many people know that they need to get this done, but they haven't done it yet. And therefore, they remain stressed about the process. So I would like to assert to you that by completing your estate plan, you're going to take some stress out of your life and get it done. By the way, as a part of every package, our firm completes the funding with you so that you know that rather than a pile of papers, you actually have taken care of your heirs for years and years to come. Thank you so much for joining me today. I'm John Miller, founding attorney of Rock Solid Law and Title, and I'll see you next month for another webinar. Let us know if we can help you or someone you know and love.